6 minutes.
Madam Chair. Thank you, Madam, for being here. Your role is vital to our democracy. My former colleague, Pat Martin, used to say that access to information was the oxygen and lifeblood of the democratic process. And every government that comes in, including this latest one, their first promise is open government. And then the first thing they do when they realize that what's open government is means people can ask questions about bad decisions, they start to try and find all manner of ways to not have open government. So there's a number of tricks. Cabinet confidence. I think that's section 23. No, that's solicitor's client. That's the second one. Solicitor client, cabinet confidence. And then the great one was the great black hole of ministerial offices. Now, that used to drive your former colleague, Commissioner Madame Legault crazy, that how could it be that anything that goes on in a minister's office has to be protected from the public finding out anything, because that's where all the decisions are made. Under Bill C-58, did any of that change?
Under Bill C-58, there's Part 2 now, the proactive disclosure. So what they've done is they codified basically the policy that existed before on proactive disclosure, and it is also applied to a number of new institutions, including the minister's office, the Senate, the judges.
Oh, the Senate, yes.
So the proactive disclosure is one way to open up, and it was something that was added. But there's a difference between my role, which is under Part 1 to investigate access requests. The Part 2, which is proactive disclosure, is outside of my mandate. One thing also that was added, and I thought I was going to be happy with this, but they added the name of the staffers of ministers' offices and their title are not anymore considered private information, personal information. The problem is they're not considered like public service still. So all you can receive is the name of the staff and their title. But if there's other information related to that person, they're not considered like a pure public servant, which the information of a public servant under the Privacy Act, if you're not aware, their name, their title, their opinion, anything related to work and what's related to the business is not considered personal information. So they've made a difference between the two.
Well, there's a difference between proactive disclosure and right to access documents, and I would refer my colleagues back to 2011 when Tony Clement managed to get $50 million in border security money diverted to Muskoka to spend money on gazebos and sunken boats, and all that was under ministerial privilege, and we couldn't find out how he spent a dime until we went to the municipalities, where, thanks to their Access to Information Act, we found they had homemade applications for spending money and that's how that got out. But if it was under the minister's office, we knew nothing. So is making sure that we have access, or at least giving you the right to decide, I think that's the fundamental question. I can't say if it's cabinet confidence, you can. It seems to me that it's interfering with your work if you don't have the right to decide whether or not those documents do fall under that, or they're just being needlessly protected.
I agree. I think that it should be like the solicitor-client privilege is one of the most protected privilege, and but I still entitled to see the document. And I can tell you, Canadians trust when somebody who's not the institution. If we have a document in front of us and we tell the person, yes, what you receive is blacked out, that it's redacted because it's a legal opinion or it's protected by Section 23, like you say. It reassures Canadians, and I think the same thing would happen with cabinet confidence. Yeah. If we were to be able to confirm, to see it, and not release, we don't release documents. We would never ourselves give disclosure to a document. We then talk to the institutions and ask them to release or make an order, and if they don't agree with my order or my recommendations, they can go to court, and there's nothing disclosed until a final decision is made.
Okay, well, let's talk about that, because in 2014, I asked the government, which was then the Conservative government, for notes regarding the political decision to withhold the 10,000 pages of police evidence of the crimes that were committed against children at St. Anne's Residential School. I was not looking for those police documents. I don't have a right to them. I was asking for the emails, the political decision that went into that act, which should have been covered, it was delayed, and then the Liberals came in and then just said, no, we're not going to let you see them at all. Your predecessor took them on. We spent many years. In fact, she threatened to take them to court. They agreed finally to give me the documents in 3 batches. I'll bring them in if people want to see them. 3 batches of blacked out documents of every email saying, hey, Mary, how's it going? Blacked out. Hey, Bob, blacked out. So it strikes me as if the Justice Department just waits out. I mean, it was 7 years we fought this battle. They were threatened with going to federal court, and they still blacked out to protect the minister. With your order-making powers, could you have changed that decision, or do they have that power to just defy and not turn over documents that should be within the public realm?
Well,
You have 20 seconds.
I can order production of documents, except for the cabinet confidence, but I can also, yes, if I make an order that the disclosure should be done or that exemptions should not be applied, it's now the onus is on the institution to go to court, not on me to fight the decision.
Okay, thank you.